Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 4th to 8th, and today is April 11th, 2016. Two individuals settled a civil enforcement action by the Commodity Futures Trading Commission alleging that they engaged in spoofing activity by agreement to pay an aggregate fine of $2.69 million US, while a third individual's recent criminal conviction for spoofing was not set aside by the relevant court despite his motion for such relief. Separately, staff of the CFTC once again delayed effective dates for obligatory filings under its new ownership and control requirements, clarified definitions of owner and controller, and provided some interim relief on the effective dates of certain other specific requirements of reporting entities. It feels like winter today, well into spring in New York City, so I can hurry and unpack my winter clothes in time for summer. Let's get started. Late last week, staff of the Division of Market Oversight of the Commodity Futures Trading Commission again delayed the rollout of new large trader reporting requirements that initially were adopted during November 2013 and most recently scheduled to go into effect beginning later this month. Under the new revised schedule, new electronic reporting requirements are delayed until the earlier September 29, 2016, and in one case delayed until August 30, 2018. In the interim period, record-keeping requirements that became effective on August 14, 2014, and legacy non-automated reporting and other requirements are in effect. Entities required to file the relevant forms are also expected to cooperate with CFTC staff to test and implement relevant information technology standards and systems. As part of its no-action relief and OCR guidance, DMO staff also agreed to extend the time period by which certain other specific OCR requirements would apply. For example, reporting parties obligated to file new forms beginning September 29, 2016 will not be required to include certain detailed information regarding trading account controllers, for example, phone number, name of employer, Employer National Futures Association identification number, and employer legal entity identifier, until August 30, 2018. Staff also increased the reporting trigger for volume threshold accounts under new Form 102B to 250 or more contracts per day from September 29, 2016 until September 28, 2017, and to 100 contracts per day from September 29, 2017 to August 29, 2018. The threshold level will revert to 50 contracts per day beginning August 30, 2018. DMO staff also clarify who would be considered owners and controllers of reportable accounts under its OCR rules, as well as provided a mechanism for reporting parties to identify to the CFTC for an interim period a client that does not provide it with adequate information to identify a trading account controller as required on the requisite form. Last week, the judge that recently oversaw the trial of Michael Coscia in a U.S. federal court in Chicago declined to grant Mr. Coscia's motion for acquittal or a new trial. In November 2015, Mr. Coscia was convicted of 6 counts of commodities fraud and 6 accounts of spoofing in connection with his trading activity on CME Group exchanges and ICE Futures Europe from August to October 2011. Mr. Coscia subsequently filed his motion, claiming, among other things, that the prosecution misapplied the relevant standard for proving commodities fraud and that the law prohibiting spoofing is void for vagueness. The court rejected both arguments. Heat Carrara and Nassim Salim agreed to settle charges brought against them for alleged spoofing activity from January 29, 2015 through March 13, 2015 involving gold and silver futures contracts traded on the Commodity Exchange Inc. The defendants were initially sued by the CFTC for this activity on May 5, 2015 in a federal court in New York. At the CME Group on April 30, 2015, summarily barred Mr. Carrara and Mr. Salim without a hearing for trading on any CME Group exchange for 60 days. In its complaint, the CFTC alleged that Mr. Carrara initially, alone, on numerous occasions, placed late orders on one side of the market with intent to cancel the orders before execution to induce a run-up or run-down of relevant market prices. At the same time, he placed one or more smaller orders on the opposite side of the market to be executed when the market increased or decreased in price. Later on, Mr. Carrara and Mr. Salim, working together, placed layering orders and orders to be executed, claimed the CFTC. To resolve the CFTC charges, Mr. Kara agreed to pay a fine of US $1.38 million, while Mr. Salim agreed to pay a fine of $1.31 million US. Both individuals also agreed to never again trade on a CFTC-registered execution facility, among other sanctions. Michael Pucciarelli and Badge Trading, a company wholly owned by Mr. Pucciarelli, agreed to pay a fine of $280,000 US and be barred from trading on any CFTC-supervised execution facility for 4 years as a result of engaging in numerous non-bona fide exchange for physical transactions from January 2010 to August 2012. Previously, in July 2014, Mr. Pucciarelli also agreed to settle charges by IFUS US related to the same alleged wrongdoing by agreeing to disgorge profits of approximately $514,018 US and being subject to a 2-year trading ban on all IFUS US operated markets. And finally, the Basel Committee on Banking Supervision proposed changes to banks' leverage ratio calculations to better differentiate between margin and non-margin derivatives trades. In case you forgot, the leverage ratio refers to the amount of shareholder equity and disclosed reserves a bank must maintain divided by its total exposures. Under Basel III, banks are expected to maintain a leverage ratio of 3%, while the Board of Governors of the Federal Reserve System expects most insured bank holding companies to maintain a leverage ratio of 5% and systemically important financial institutions of 8%. Unfortunately, the Basel Committee did not at this time propose to amend such calculations to better account for initial margin posted by clients in connection with clear derivative transactions. Currently, under banks' leverage ratio calculations, a measure of potential futures exposure in connection with derivatives transactions is not reduced by the amount of initial margin posted by a client. As a result, banks must maintain a greater amount of capital in connection with clear derivatives business than if offsets were permitted. However, the Basel Committee agreed to collect further evidence and data, quote, to assess the effects of the Basel III leverage ratio on the client clearing business model and the need for banks to have adequate capital to support their clearing activities, end of quote. The Basel Committee will accept comments on its proposals through July 6, 2016. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, stay warm and ciao.